Hello, everybody. Hope everyone is staying inside and safe. 3 cheers to Zoom meetings. There is so much news out there regarding COVID and its impact on immigration that it can get really overwhelming. So today we're actually going to take a break from COVID and talk about something that will continue to impact foreign workers in the coming years, COVID or no COVID, and that is the H-1B lottery system. Every year for the past at least 7 years, USCIS has been conducting a lottery to fill its H-1B quota. USCIS has set aside about 85,000 H-1B visas, out of which 65,000 is for regular H-1B applications and 20,000 for those beneficiaries who have earned a US master's degree or higher. Every H-1B cap season, USCIS receives about 2 or 3 times the number set by this congressionally mandated cap, due to which they have to conduct a lottery to select those lucky 85,000. What about the ones who do not get selected? In this video, we're going to talk about several options that foreign nationals have in case of non-selection in this coveted H-1B lottery. The first thing we're going to talk about is the STEM OPT extension. If the H-1B candidate is already in US on OPT, he or she may be able to continue working and staying in the US by extending their OPT if they qualify under the STEM program. If the candidate holds a STEM degree, it would qualify them for a 24-month STEM OPT extension. Now, this extension must be filed prior to the expiration of the current OPT, and the employer must be e-verified. These are just some of the requirements that one must meet to qualify for the STEM OPT extension. The second option that they have is filing an H-1B with a cap-exempt employer. Now remember, the 85,000 quota is for cap-subject employers. There are plenty of employers out there who are not subject to this cap. That is, they are cap-exempt and are allowed to sponsor a foreign national at any time during the year. A cap-exempt employer is defined as an institution of higher education related or affiliated to a higher education institution nonprofit entity, or a nonprofit research organization or a government research organization. This option may also work if the foreign national is being placed in one of these institutions, but not actually sponsored by a cap-exempt employer. If you think that you could be sponsored by an entity that could fit this criteria, contact an immigration attorney so they can then evaluate the employer. The next option is the L1 intra-company transferee. This option is available for those foreign nationals who have been employed by a company at their overseas office for more than a year in either a multinational executive manager capacity or as a professional employee with specialized knowledge. This is a really good option for employers with overseas offices who have the option to relocate their employees for a year and then bring them back on an L1. Also, spouses of an L1 visa holder can get a work permit. The next option is the O1 and T1 visas for aliens with extraordinary ability. Aliens with extraordinary ability in science, art, education, business, or athletics can qualify for an O1 or P1 visa. We actually recently had a case where a foreign national with excellent credentials in the field of science did not get selected in the H-1B lottery. After evaluating his case, we decided to go forward with the O1 and it worked for him. Now, obviously, this option may not work for everyone, but it is worth looking into with an immigration attorney. The next on the list is TN for Canadian and Mexican nationals. This visa is specifically designed for Mexican and Canadian nationals who are coming to the US to work in one of the designated occupations by NAFTA. The process is slightly different for Canadian and Mexican nationals, but it's not subject to a cap. The next is E1, E2 treaty trader or investor visas. For foreign nationals of certain countries with a treaty with the US, an E1 or E2 is an excellent option. E1 visa is for foreign nationals working for companies that have significant trade between the treaty country and the United States. And the E2 visa is for foreign nationals who want to invest in the US, not to be confused with the EB5 investment-based green card. Another thing, just like the L1, dependents of both E1 and E2 visa holders can obtain work permits. The next is the E3 visa for specialty occupation workers from Australia. To qualify for an E3, the foreign national must be a national of Australia. He must be coming here to fill a position that qualifies as a specialty occupation. He or she must also possess the necessary qualifying credentials and have a job offer in the US. So basically an H-1B, but only for foreign nationals from Australia. The last option we're going to talk about is directly filing for a green card. This option is optimal for foreign nationals who are not from India or China, and hence they don't have a significantly long wait time before obtaining a green card. Their employers can directly sponsor them for permanent residence and bypass filing for an H-1B altogether. But whether the timeline would work for an individual candidate depends on a case-by-case basis, and this option should be evaluated with an immigration attorney. So as you can see, there are options if you're not selected for the H-1B lottery. So talk to an immigration attorney to thoroughly evaluate your case if you think one of these options would work for you. We here at Pollack, Isaac, and DeCicco are offering consults through phone, Skype, and Zoom. So let us know.